Hello friends, very good morning to all of you. Now we will see some important editorials that have appeared in the Hindu newspaper. So today in this session I have taken two editorials. One appeared on Saturday, that is India does have a refugee problem. Friends, uh, this is about the India's refugee policy, which is majorly an ad hoc policy. I mean, the Indian government is responding case by case, situation by situation, and there is no permanent policy. And the this article talks about the need for a refugee policy, a refugee act, so that the authorities can follow a stable and permanent policy towards the refugees. Friends, the second article I have taken is about the data protection law. Friends, in the COVID-19 situation, the digital exposure of the people has been increased manifold, especially in the arena of digital economy. Friends, in this context, there is a need to protect the data rights of the people, and also we need to protect their privacy rights over their personal data. Friends, in this context, we need to adopt a robust data protection policy, and we need to enact a data protection law that protects and ensures the rights of the people over their data, and as well as the law protects the privacy rights of the people. So friends, these are the two articles that I have taken for today's discussion. Friends, let us go through the first article, that is India does have a refugee problem. It needs to clinically address the issue of refugee protection and introduce appropriate legal and institutional measures. So India should address the issue of refugee protection, and it should introduce appropriate legal and institutional measures. Friends, here an incident has been discussed. Friends, this is about the Myanmar citizens. They are escaping the country due to the violence, and they are found at the Indian borders trying to enter into India at the northeastern border, and they have been refused, and they have been declined by the Indian authorities. Friends, this incident once again stirs the debate around the refugee protection in India. Friends, there was another incident about the same country and same citizens, the Myanmar citizens, that is about the Rohingyas. Uh, I mean, a couple of years back, 2 years back, the Rohingyas were fleeing the country and were entering. Majorly, they entered into Bangladesh, and some came to India, but they have been declined by the Indian authorities. Friends, and one more incident is there, that is the NRC and the Citizenship Amendment Act 2019. It has also discussed in the context of refugees. Friends, it has some relation with the refugees, because the people who have entered into India, they have they will get the right to become the citizens of India, and the cutoff date for such a right was 2014. Friends, so if we observe all these scenarios, it is highly unlikely that the immigration or refugees, those are coming into India, is going to end at in the future. It seems that more and more refugees and immigrants are going to come to India. Friends, uh, because India is situated in a situated in certain circumstances. Those are geopolitical, economic, ethnic, and religious context. If we see, so it is hardly going. I mean, the inflow of people into India is hardly going to end, friends. So therefore, there is an urgent need today to address the issues of refugees as well as the immigrants. First, we have to differentiate between the immigrants, especially the illegal immigrants and the refugees, and we have to adopt a proper and permanent mechanism for the refugees. So there is a need for legal and as well as institutional measures. Friends, there is a lot of confusion between the refugees and immigrants. So now we will clarify what are I mean who are refugees and who are immigrants, and what is the differences between them, what are the differences between them, and what rights does refugees have and what rights does immigrants have. Friends, India emphatically argued over time. It is saying that the illegal immigration from the neighboring countries must come to an end. So India is complaining that illegal immigration from neighboring countries must end in order to secure India's borders, and as well as the immigrants are leading to some political, economic, and as well as social problems, especially in northeastern India. Friends, the illegal immigrants, it is said that almost 1 crore illegal immigrants are there in India, one estimate says, and there are some illegal immigrants. I mean, there are some illegal immigrants even from Myanmar also. So India is saying that illegal immigration into India must end. Friends, there is also a little doubt that it is a threat to socio-political fabric of any country, including India. So illegal immigration is a socio-political, it is a threat to socio-political fabric of any country. It is the same case with India. And it also has potential security implications. Friends, um, in this context, still there is a debate about the sources and as well as the implications of illegal immigration into the country. Friends, in this debate, in the debate of the illegal immigrants, the issue of refugees is tends to be submerged or overlooked by the authorities, and often the issue has been put into back burner, and I mean because of the issue of illegal immigrants. Friends, this because of this, what happens, neither of which do justice to the helpless people fleeing from the persecution at home. So because of the illegal immigrants issue always runs in the front, the refugees who need genuine help, they become helpless and their issues will not be addressed. Friends, because of the lack of clarity, these two categories, both the illegal immigrants, or should I say the immigrants, and the issues of immigrants, both of them are bunched together. So this is not at all a welcome development. So friends, because we have jumbled these two issues over time, the policies and remedies to deal with these issues suffer from lack of clarity and as well as policy utility. So because we are clubbing these two issues, there are problems of lack of clarity and as well as policy utility. Friends, now we will try to understand the ambiguity in the framework. I mean, what are the frameworks, legal and other frameworks that exist regarding the refugees, and the ambiguity surrounding these frameworks. Friends, the major law that deals with immigrants as well as refugees in our country is the Foreigners Act of 1956. So all these people, both immigrants and as well as the refugees, are covered under the Foreigners Act of 1946. Friends, this act, the problem is it offers a simple definition for a foreigner. So what is the definition the act gives? Foreigner means under this act a person who is not a citizen of India. Friends, this is a simple definition and often this is becoming a problem. So friends, uh, there are fundamental differences between illegal immigrants and refugees, but India is legally ill-equipped. So means there is no legal mechanism that differentiates between the illegal immigrants and the refugees. So this is because of the lack of legal provisions. Friends, we also have to remember that India is not a party to the 1951 Refugee Convention, and there is a protocol under this convention, that is 1967 Protocol on Refugees. So India does not a party to these convention as well as the 1967 protocol. So the only legal mechanism that exists in India is the Foreigners Act of 1946, and the problem is it vaguely defines the uh, immigrants. It vaguely defines the foreigners, right, friends? So because of this insufficient legal framework, so the refugee policy in India is primarily guided by ad hocism, means temporary in nature, which of course often has its own political utility. Friends, because of this ad hoc policy, the cases are dealt time by time and time to time, and depending on the circumstances at the time. So this ad hoc regime has its own political utility. The government at that time, the government that has that will be in power will use the issue to its advantage, right, friends? The ad hoc measures enable the government in office to pick and choose what kind of refugees they want to admit and what kind of refugees they do not want to accept. So this becomes convenient for the government at that time. Friends, the absence of legal framework increases the possibility of the domestic politicization of refugee protection and complicates its geopolitical fault lines. Friends, the illegal immigration from Bangladesh is a classic example for this. So because of the illegal immigration of the Bangladeshis into the Assam, especially the northeastern state of Assam, it became a political issue between the different political parties, and as well as when the government has brought in the NRC, National Register of Citizens, and it became a geopolitical problem between Bangladesh and India. Now Bangladesh is raising concerns about the NRC and NRC that has been taken by the government of India. So it became a stumbling block between the India and Bangladesh. Friends, the absence of clarity laid down in the refugee protection, this also leads to geopolitical considerations while deciding to admit refugees or not. So, for example, India refused to admit the the Rohingya migrants. When they flee from Myanmar. So India refused to admit them. Right, friends? If we consider the present case, the people, citizens of Myanmar who are fleeing because they want to escape the violence by the junta. So consider this case, friends. Indian authorities declined to accept the fleeing citizens of Myanmar because they fearing that the authorities, Indian authorities, are apprehensive of the generals in Naypyidaw, the junta that is holding power in Naypyidaw. Friends, if India accepts the migrants, the junta, the generals might tend towards Beijing, and they become close with China, and India will be sidelined from the Myanmarese regime or Myanmarese authorities. So, because of these reasons, India is now not accepting the fleeing citizens of Myanmar into India. Friends, now we try to understand the legal and moral complexities regarding the refugee issue. Friends, in the past, we have a stellar record, we have a good record of in the issue of refugee protection, as we have accepted, we have been the largest recipients of the refugees in the world, in spite of not being a party to the 1951 Refugee Convention and the 1967 Protocol. So India has a stellar record in accepting the refugees and protecting their rights. Friends, there is a debate that whether India should accede or become a party to this 1957 convention or not. Right, friends? The author here clarifies that India should not become a party because there are some problems associated with the 1951 convention, because it is less than a perfect there are some problems in interpreting the 1951 convention. That is one thing, and the Western countries are not perfectly implementing the convention, right, friends? So the Western countries are picking and choosing in interpreting the convention. So this is the second problem, right, friends? While the Western countries are considering the political rights and the legal rights of the citizens who are fleeing the countries, and they are refusing to recognize the economic deprivation of economic rights, because if they want to fulfill the economic rights of the refugees, it will become a burden on them. So they are not considering the economic rights, they are considering only legal and political rights. So because of these reasons, India should not become a party to the 1951 convention. Right, friends, the same issue the here discussed here about the lack of acceptance of economic rights under the 1951 convention. Okay, friends, if we see, the scholar B.S. Chimini has argued India should not accede to 1951 convention at a time when the North is violating it in both letter and spirit. Right, friends? And India also arguing that the Western states, the developed countries are following a regime of non-entry, that is no entry, through various means. Those are the no entry or non-entry regimes include the both a range of legal and administrative measures that include visa restrictions, career sanctions, interdictions, third safe country rule, restrictive interpretations of the definition of refugee, and withdrawal of social welfare benefits to asylum seekers, and widespread practices of detention. Friends, an array of these kind of both legal and administrative measures, the developed countries are shutting their doors for the immigrants. So this is a biased policy that has been followed by the developed countries. So friends, so in this context, friends, India must use its exemplary, though less than perfect history of refugee protection to begin a global conversation on the issue. So India First point is India should not accede to the 1951 convention because it has some problems with its interpretation. And the second one is the West is not 100% sure about the, 100% implementing the immigrant policy or the refugee policy. So India, with its almost perfect refugee policy, refugee track record, it can start a new discussion for the transparent and a justifiable refugee policy. So friends, so what is the solution? There is no proper. There is no proper permanent policy in India, and the existing international conventions are not transparent or not perfect. So what is the solution? Friends, the solution is the answer is we need a new domestic law aimed at the refugees. Right, friends, the CAA, if we consider the Citizenship Amendment Act, this is not an answer to the problem because the author feel that it is discriminatory in nature. The CAA is discriminatory nature. So this is morally untenable to have a discriminatory law to address the concerns of the refugees. So this is the opinion of the author. The CAA is not a solution. Friends, if we speak honestly, the author feels that the CAA is an effort to refuse the refugees an entry into India. So this is the opinion of the author. Friends, the author feels that the whatever law the Indian authorities are going to, if at all the Indian authorities are going to enact a law regarding the refugees, it should allow for the law should contain temporary shelter and work permits to the refugees. So it should include these mechanisms. Those are it should provide temporary shelter and it also should provide work permits to the refugees. Friends, this is crucial because absence of proper legal measures, so like refugee documentation and work permits, if they are not available, so the refugees may end up becoming illegal immigrants using illicit means. So it leads to more complication of the problem, and subsequently the refugees will become the illegal immigrants. Right. So if we put it plainly, the absence of a refugee law incentivizes illegal immigration into the country. So this is the danger with the absence of a proper refugee law, friends. Also, the government authorities make a distinction between temporary migrant workers, illegal immigrants, and refugees, and deal with each of them differently through proper legal and institutional mechanisms. Right, friends? Our tradition or practice of adopting a ad hoc and ambiguous policy towards refugees has become and proved deeply counterproductive. So, friends, this policy, ad hoc policy, neither protects the refugees nor helps stops illegal immigration into the country. So, the solution, the fair way forward is we should have a robust new domestic law that addresses the concerns of all of them, temporary immigrants, illegal immigrants, and as well as the refugees. Right, friends, this is all about the article, and it is a good and thought provoking article. Right, friends, now we will see the second article, that is why personal data protection bill matters. The proposed regime under the bill seeks to be different from existing regime which does not adequately protect users' data. Right, friends? The author here discusses about the context of COVID-19 and how people have increasingly utilizing the digital arena, and especially depending upon the digital economy, and as well as for depending on the online or cyberspace for needs like purchasing groceries to accessing health services. So the digital footprint has increased enormously. Friends, in this context, unfortunately, the number of personal data breaches have also increased. So the author here discussed the example of MobiQuick data breach, in which almost 9.9 crore Indians' personal data is at risk. Friends, in this context, there is need for a robust data protection regime to prevent such data breaches and protect users' interests. Friends, the existing regime is insufficient or old to address these kind of developments or these kind of data breaches. Friends, if we understand the present regime, present uh, legal, uh, legal, legal mechanism that is there in our country, it is the Information Technology Act. Friends, the present legal mechanism that is available is the Information Technology Act 2000, and there are other sectoral regulations pertaining to each and every sector. Friends, this data protection regime falls short of providing effective protection to users and their personal data. Right, friends? If we understand why the existing regime is insufficient or inefficient of protecting the personal rights of the users over their data, is the entities could override the protections in the regime by taking users' consent to processing of personal data under broad terms and conditions. Friends, the entity will be providing n number of terms and conditions, and the user have to give his content en masse for all the terms and conditions with a single click. Okay. So under the broad terms and conditions, the authorities or the cyber authorities are taking the consent of users. Right, friends? This is problematic given that users might not understand the terms of conditions or the implications of giving consent. Right, friends? And the second problem is the existing framework does not emphasize enough on data privacy. So privacy, friends, security is one issue, and the next issue is data privacy. The regime do not give proper emphasis or enough emphasis on data privacy. Friends, in essence, the entities have to employ technical measures to protect the personal data, and they have weaker obligations to respect users' preferences in how their personal data can be processed. And because, friends, because of these uh, imperfect obligations of the cyber entities or online entities, I mean they could use the data, people's data, for the purposes different to that of the user consented to do. Friends, we have given consent to do some things with our data, but in effect, the cyber authorities or the online entities are using this data for other purposes also. Right, friends? The data protection provisions under the IT Act also do not apply to government agencies. Friends, the IT Act 2000, and data protection rules under this do not apply to government entities. Friends, this creates a large vacuum of data protection when government authorities also collecting huge data from the people. Right, friends? And the regime seems to have become antiquated. That means it became too old and inadequate in addressing risks emerging from new developments in data processing technology. So the regime became old and inadequate as the time passed by, because a lot of developments have been taken place since the IT Act 2000 has been passed. Friends, this needs for a robust data protection legislation. The need came when the in the case of right to privacy judgment, where the right to privacy has been declared as a fundamental right by the Honorable Supreme Court in case Puttaswamy versus Union of India case, and the government subsequently constituted B.N. Sri Krishna committee to suggest a draft data protection law. And the current data protection bill is the revised version of the draft legislative document that has been given by the Justice B.N. Sri Krishna committee. Right friends, now we will try to understand about the upcoming regime, that is the upcoming data protection law. Right friends, the bill that is coming, the act that is going to come seeks to be different from the existing regime. Existing regime is IT Act 2000. This is the existing regime, and the upcoming bill seems to be different. Right friends, if we see the differences, the upcoming bill or a regime seeks to apply to both the government as well as private entities. Right friends, the existing regime applies to only private entities and not to government entities. Friends, the upcoming bill also tries to emphasize both on security as well as the data privacy. Hence, apart from maintaining security safeguards to protect the personal data, they have to fulfill a set of data protection obligations and transparency and accountability measures that govern how entities can process personal data to uphold users' privacy and interests. So they have to follow a transparent and accountable measures that how they are going to process the users data. Right friends, this is the second important difference. Friends, the third one is the bill seeks to give users a set of rights over their personal data and a means to exercise those rights. Right friends, for example, the users will be able to obtain information about what kind of different personal data has been an entity is collecting from them, and how this data is being processed. Friends, for example, we all use Uber cars, and also we order food from Uber Eats. So in the upcoming regime, the user can know how the Uber is collecting how it is collecting data from our travels and what we are eating, and how it is processing this data. So now the user can know about the what should I say, amalgamation of this data and how the data is being processed. Right friends, the fourth and very important thing is the bill is going to create the Data Protection Authority, DPA, and the DPA will monitor and regulate data processing activities to ensure that their compliance with the regime. So it will ensure, Data Protection Authority will ensure the proper implementation of the bill itself, and the authority, the entities are following the rules. Right friends, the second important thing is the DPA will give users a channel to seek redress. So the DPA will work as a grievance redressal authority. Right friends, overall the bill seeks to bring a massive, meaningful change to personal data protection in India through this regime. So overall it wants to bring in a meaningful change in personal data protection. Right friends, but there are some problems with the data protection regime that is going to come also. Right, friends? Why this situation? I mean, why it seems like that? Because there are several provisions in the bill that create cause of concern about the bills, upcoming bills, effectiveness. Because, friends, I mean, the government can issue exemptions to, I mean, the bill has provisions to exempt government agencies and dilute user protection safeguards, right? Also, friends, under the clause of 35, the central government can exempt any government agency from complying with the bill. Right, friends. The government agencies will then able to process personal data without following any safeguards under the bill. So major problem is government can exempt any obligations under the law. So then the, I mean, data of the people can be processed without any restrictions. Friends, the other thing is users could find it difficult to enforce various rights that have been guaranteed to them. For example, the bill threatens legal consequences for users who withdraw their consent for data processing. So, because of this, I mean, criminality or the fear of punishment, the users might not come forward and withdraw their consent for the process of their data that belongs to them. Friends, as well as the additional concerns regarding DPA. I mean, we all know the situation of regulatory authorities in our country and the problems associated with their working, and the same problems might affect the data protection authority also. Right, friends? These are some of the positives and as well as the challenges associated with the bill. And the bill is at the present with the JPA, Joint Parliamentary Committee, and it is expected that the bill is going to be introduced in the monsoon session, the upcoming monsoon session. So we have some time. So the government or the JPA will consider these measures, and the both houses of Parliament shall I mean, they have come forward to accept the suggestions given by the expert, and let us hope that we will see a robust and a perfect, near perfect data protection bill for the benefit of the country and for the benefit of all of us. Right, friends? Thank you for joining me. Have a good day. See you next time.